Okay, this is WMU Criminal Justice Policy 3250 with distance learning number 5. If you look at our syllabus, it'll be the March 30th, 2020 date, where we're going to talk about jury trial and jury selection. This is chapter 9. You should read section 9.11 in that book. It's only a couple of pages long, and I want to highlight some of the important things as it relates to jury trial and jury selection. Again, March 30th, 2020 on the syllabus. We'll call it distance learning number 5. The first of the remaining learning sessions after the second examination. So we know from the Constitution, not in one, but in two places, that individuals have the right to have a jury trial when it comes to a criminal matter. It states in Article 3, Section 2 of the original Constitution that trial of all crimes except impeachment shall be by jury. It also states that in the Sixth Amendment that in all criminal prosecutions, the accused shall enjoy the right to a trial by an impartial jury of the state. So it is obvious, based on what's written in the Constitution, the original one, as well as the amendments, that having a jury trial when somebody is facing criminal liability is significantly important. So the first article that we talked about, Article 3, Section 2, talks about trial of all crimes except impeachment shall be by jury. I would be remiss if I didn't say that this was significant during 2020 and 2019, as Article 1, Section 3 talks about the Senate getting to do impeachment trials. We faced that earlier this year with respect to President Trump. We don't have this too much in our history. We've had it a few times, but it's an example where the Senate decides, that is, instead of a jury, but the Senate decides issues having to do with impeachment. Turning back to what it is that we're spending our time talking about, however, that is the run-of-the-mill individual charged with a crime. Do they have the right to have a jury trial? And the answer to that is yes. Sixth Amendment is what we rely specifically upon. And we've also talked about other things dealing with the Sixth Amendment. As you recall, we finished up talking about an impartial jury. We spoke about how you get to be an impartial jury. When we deal with things like pretrial publicity, making sure that individual jurors do not have a stake in the outcome, don't have relationship with the participants. That's how we get to an impartial jury of the state. But it's important to spend some time talking about the idea of actually having a jury decide whether or not somebody should face criminal liability. If you were and I were all in the room together, I'd ask you the question, why? As I do with many of these particular constitutional provisions, why is it that the government is required to go through a jury in order to convict somebody of a criminal act? We get some answers to this from Duncan versus Louisiana, which is referenced at page 469. It's another example of preventing oppression by the government on the people. We felt strongly about the government having too much authority, and in order to avoid having a level of oppression by the government on the people, at least as it comes to the issue of guilt in a criminal proceeding, we afford individuals charged with crimes to have a jury make the decision. You may have a very qualified judge who could make the decision, but an individual has the right to have a jury make the decision. And it's so important that we included it in the Sixth Amendment. This right has been incorporated by the states. That is, all the states have accepted this. It's a responsibility in all the states. And we look at the language in all criminal prosecutions to see whether or not this actually is true. A couple other reasons why it is that we want to make sure that the individual has a right to a jury trial is that citizens of a community have the ability to participate and evaluate the process. That's another good reason why it is that we have jury trials. The community sense of justice is included in the justice system through verdicts. That is, When rendering a verdict, the community is expressing their opinion about whether or not their government, the one that's prosecuting, whether it be at the local level, the state level, or the federal level, that their government is doing what we want them to do. There's a shared public responsibility. When this happens, it enhances public confidence in the overall system. So these other reasons, not only the individuals having the right to have a jury decide on it, it's important that the jury is part of the process so that the community can understand what's going on and speak a bit about what their thoughts are. I recall when I was a prosecutor in my early days, I prosecuted 3 prostitution cases in town, misdemeanor offenses, and I believed and had all the requisite evidence necessary for the individual to be found responsible and have the jury reach a verdict of guilty. But in 3 consecutive cases, the jury rendered not guilty verdicts. Now, I don't mean to besmirk the jury in their decision making, but I believe part of the rationale was the jury speaking out and saying to the government, which I was a part of, that we don't want our local government working on cases such as prostitution. Not that it wasn't a crime, not that the legislature shouldn't make it illegal, but the community rendering those verdicts, in my opinion, in part at least, was a sign to our local government system that maybe our energies, our monies, our efforts should be focusing on something a bit more severe than cases of prostitution. Again, the community's sense of justice is included in their verdicts. So, as I mentioned, we want to talk about whether or not it is true that in all criminal prosecutions, the accused shall enjoy the right to a trial by an impartial jury of the state. That's what the language of the Sixth Amendment says. But we find that this isn't 100% accurate. In the case of Baldwin versus New York, at page 470 in your textbook, the Supreme Court rendered a decision that said that the right to a jury trial includes serious but not petty offenses, petty being Petty, petty being defined as anything that is 6 months or less of incarceration. So what Baldwin said was that if in fact someone is charged with a crime and the possible penalty is less than 6 months incarceration, that is a petty offense, and one's right to a jury trial does not extend to petty offenses. In other words, that even though the Sixth Amendment says that in all criminal prosecutions the accused shall enjoy the right to a jury trial, that does not apply if the offense is petty. Now, I'm not saying that states don't afford individuals the right to a jury trial for petty offenses, but Baldwin seems to suggest that they don't have to. State governments can obviously permit jury trials for petty offenses. And in fact, the state of Michigan provides a jury trial for all criminal offenses. Again, affording the members of its community more rights than what the federal government requires. And in Baldwin versus New York, it's important to recognize that petty offenses do not have the right to have a jury trial. That is, a jury render a decision. There is no right to have a jury trial as it relates to sentencing. That's important to understand. The book speaks about it a little bit. The decision of whether or not somebody is guilty of a crime, that is what is extended to a jury trial. So there's no right to a jury trial on the issue of sentencing. Certainly some state governments have elected to allow jury trial decisions on sentencing on certain matters, most notably those that involve the death penalty. And we'll talk about that when we get to the issue of punishment. So the sentencing phase of the criminal justice system does not guarantee one the right to have a jury trial for most offenses. It's only the decision of whether or not they're guilty of the offense. So let's speak a little bit about how we get to an actual jury. The first thing that we should understand is that a jury, which we know from the Sixth Amendment, must be impartial, and that they must come from the community in which the incident occurred. That is, if the crime occurred in the state of Michigan, you can't bring in people from Ohio to render the decision. So we know that it comes from a select group of people within the confines of who's bringing the prosecution. So in Michigan, how we do it is that we break each county up into a circuit. As I mentioned before, Kalamazoo County is a specific circuit. Within that circuit, we have a circuit judge and district judge and probate judges. If a crime occurs within the confines of this county, that is Kalamazoo County, and it's being prosecuted by a state prosecutor, then all of the people who are eligible to be jurors must be residents of the county. That is Kalamazoo County residents. The same is true if you talk about Berrien or Calhoun or Washtenaw or Wayne County. Where the crime occurred, that's where you grab the individuals who make up what are known as the jury pool, or as we like to call it, the jury veneer, V-E-N-I-R-E. What happens is that each county has a jury clerk, and that clerk sends out to individuals who live in the community who are able to be jurors notices of their requirement to come to court to potentially be an actual juror in a case. So the jury veneer is a large number of jurors chosen from the community to be brought to court to decide whether or not they should actually sit on a jury. My first question that comes to that is, how does the jury clerk know who to send these to, and is it done randomly? So how does the jury clerk get to know an individual and then issue what is known as a jury summons to have them come to court? There are a variety of ways in which the jury clerk can gather information about an individual who lives in the community and requires them to come to court. And the ones that the state of Michigan demands is that the group come from people who are registered through the Secretary of State's office for a Michigan ID card or for a driver's license or who are registered to vote. Those three categories of people are the ones that qualify somebody to be a prospective juror, to be part of the jury veneer. So if you are not registered to vote, if you do not have a Michigan ID card, or you do not have a Michigan driver's license, and you live in the community, you will not be called in to be part of a jury. Some people ask, should not the group of people be expanded beyond those three possible targets? And the state of Michigan does not demand it. There are other ways in which you can access people who don't fit those requirements. You can get into federal databases that include social security numbers, that include tax forms and things of that nature. But the state of Michigan only requires that in order to satisfy a composition of the community that may ultimately be impartial, you only use those resources. It used to be such that we didn't use the Michigan ID card. We just used voter registration and driver's license. But there were a large number of people in the community who otherwise would be qualified, that is, they're 18 years of age at a minimum, that might fit that group. And so we added Michigan ID card because there were a lot of people, of course, who didn't register to vote and didn't have a driver's license who could sit as a juror. So those are the three requirements that we look to. You don't have to have all three, you just have to have one of the three: voter registration, ID, or driver's license. So what happens is the jury clerk has a list of all of these people who live in the county. And Kalamazoo County is roughly 250,000 people. And of those people, some of them are children, of course. Some of them don't fit those requirements. But those that do fall into a computer-generated list of people to come in randomly, to come in to be part of a jury veneer. We bring those people into court on a regular basis to hear criminal matters. And again, the large group that is brought in a given period of time is called the veneer. Kalamazoo County, we do this on a weekly basis. That is, we bring people in generally on 1 or 2 days during the week to be part of a veneer, and then we send them off to a particular courtroom to see if they will actually be a juror in a case. So with that understanding about how we get those people into the courthouse, And again, we mail them to the individuals. It's called a jury summons. Some of you may have received a jury summons. Those of you that are 18 or older, you may have received one requiring you to show up in court to be possibly part of a jury. Now, when you get the jury veneer, that is a group of people, you need to winnow that down. That is, you need to cull it down to a smaller group to actually hear a case. And in Michigan, when it comes to a felony, an individual has the right to have 12 jurors decide the case. For misdemeanors, there's 6 jurors who decide the case. Most states have a similar requirement. If it's a felony, there's 12 jurors. If it's a misdemeanor, there's 6 jurors. Some states, however, only use 6 jurors that decide a felony case. State of Florida, for example, only uses 6 jurors. We know in the case of Williams versus Florida, which is referenced at page 470, the Supreme Court says at a minimum there must be 6 jurors who should decide a jury trial associated case, whether it be a misdemeanor or a felony. And some states only use the bare minimum. Michigan provides our citizens more rights and requires 12 when it comes to a felony. What about using less than 6 jurors? Ballou versus Georgia, page 471. Georgia tried using 5 jurors, and the Supreme Court required that there be at least 6. So we know in all criminal prosecutions where an individual has the right to a jury trial, and that includes all non-petty offenses, there must be 6. And again, each state may provide more than 6 if they feel that's appropriate. So what we do is we need to get, for an example, a run-of-the-mill felony. Somebody's charged with carrying a concealed weapon. If it's a felony in that state, we bring in a bunch of jurors to sit in a courtroom that is maybe 30 or 40 jurors. And from that group, that being the veneer, we need to create a jury for a particular trial. We call that a petit jury, P-E-T-I-T. That is the number of people to sit and listen to a case. So if it's something that does not have a whole lot of notoriety, maybe a run-of-the-mill carrying a concealed weapon or possibly a home invasion that didn't gather a whole lot of attention, then the court may bring in 30 to 35 jurors in order to bring it down to 12 to hear the case. Again, the jury veneer is the larger group of people brought in, the 30 to 35. The petit jury is the smaller group, that is the number who will actually hear a case. And that word in in the Sixth Amendment that precedes the word jury is what we're trying to get at when we get to the 6 or the 12. That is, we need to have an impartial jury of the state. So that's why you bring in 35 or so to bring it down to 12, because of that 35, many of them may be partial. That is, they may know the defendant, they may know some of the witnesses, they may have themselves been involved in a similar case and can't be impartial. So that's why we bring in a greater number in order to bring it down to a smaller number, because we want those 6 or 12, depending if it's a misdemeanor or felony, to be impartial. All right? So you have a carrying a concealed weapon, you bring in 35, you go through this process in order to determine whether or not somebody is partial or impartial in order to get through 12. That's called the voir dire. That is how we determine somebody is impartial. That's a question and answer period between the attorneys, the court, and the individual juror to see whether or not they can be impartial. A back and forth question answer period. Sometimes you might see that during a movie of some sort, that Q&A. That's to show and to exhibit some type of impartiality or partiality. Sometimes, depending on whether or not the case involves a lot of notoriety or publicity, you might have to bring in more than 35. If it's a high-profile homicide case, you may have to bring in 100, 150, something along those lines, because so many people may have an opinion about the case or the individual or know the individuals involved. So it depends on the notoriety and the type of charges that decide how many we bring in for the veneer. So let's talk about what their job is as a jurors. And do they all have to agree in order to decide whether or not somebody is responsible? before I get back to the selection process of jurors. Okay, so the question is, do they all have to agree? In a criminal case, the federal court has required through the U.S. Constitution in the case of Apodaca versus Oregon, Apodaca, which is at page 471, that if your state requires 12 jurors to handle a case, then only 10 need to agree in order to find somebody guilty in a criminal case. So what happened in the state of Oregon is that the state of Oregon guaranteed rights to a jury trial, of course, through the Constitution, and had 12 jurors and decided that only 10 needed to agree on guilt or not guilty. And if only 10 needed to agree, did that withstand federal constitutional scrutiny? And the Supreme Court in Apodaca versus Oregon said, in those states which permit 12 jurors, you only need to have 10 decide. Now, they have to be non-capital cases, meaning not the maximum penalty of life in prison or death. But in non-capital cases, if you're going to have 12 jurors decide the case, you only need 10. So when you hear that there has to be unanimity by the jury in deciding the case, that isn't exactly true. If a state decides to have less than unanimity, they can do so. But there are certain limitations. First, it has to be a non-capital case, and it has to be at least 10 agreeing when there's a situation where they have 12 jurors. So with that idea, some states had said, well, we only provide 6 jurors. Can we have only 5 agree out of the 6? And in the case of Birch versus Louisiana, again referenced at page 471, the Supreme Court said no. In other words, if you're only going to have 6 jurors make a decision, whether it's a misdemeanor or a felony, they must all agree on the verdict. They must all agree that the person is either guilty or not guilty. So there needs to be unanimity when the number of jurors equals 6. However, in a state where the number of jurors is 12, that particular state for non-capital cases can require only 10 to agree. Now, what do we do here in Michigan? As I mentioned, with misdemeanors, there are 6 jurors. So we know, based on Birch versus Louisiana, if only 6 jurors hear the case, all 6 of them need to agree. Well, in felony cases, we have 12 jurors. The state of Michigan could decide, following the Apodaca case, to say only 10 out of the 12 need to agree. But in the state of Michigan, as we are able to do so, we provide our citizens more rights, and all 12 of them need to agree. That may change over time, but as it stands right now, the state of Michigan demands 12 jurors to decide a case, and they all must agree when it comes to felonies. Now let's go back to the selection process of a jury. As I mentioned, the jury veneer is to bring the individuals into the courthouse. The petit jury is the actual number, whether it's 6 or 12, to actually hear the case. We know from the Constitution that they must be people who live within the state and within the district wherein the crime was committed. And in the state of Michigan, we describe those districts as the individual circuits, which are the county. The voir dire process, once we bring them in. What's the voir dire process? That's the process, as I mentioned a moment ago, that allows the parties to elicit information to make a decision as to whether or not the juror is partial or impartial. How does this go about? Well, what happens is the court randomly brings in these people, these 30 or 35 people, and then randomly selects from that group those that will be the initial people who will be inquired of the parties. So they'll sit in the jury box in most courtrooms. Some places maybe sit in a jury room. In any event, wherever it happens, the attorneys in the court get to ask questions of the jurors to see if they are partial or impartial to the cause that's in front of them. So let's take a sexual assault case, a felony case, where we have someone accused of sexually assaulting another person. We bring in the prospective jurors, that is part of the jury veneer. We sit them in the jury box and we start asking them questions about whether or not they're suitable to be a juror. questions that may probe into whether or not they themselves have been victimized by a sexual assault. Do they happen to know the parties involved? Can they be fair and impartial when someone is charged with such a crime? Those are the types of questions we ask of jurors to determine whether or not they're partial. If somebody responds and suggests that they can't be impartial, they themselves were victimized by sexual assault, so they can't be fair to the defendant, for example. Maybe they were accused of sexual assault and they can't be fair to the government because they believe they were wrongfully accused. Those are the types of things in a sexual assault case where someone may, by this voir dire question answer period, be shown to not be impartial to the cause. When somebody is shown not to be impartial, then they can be excused from the jury for cause. It's known as a challenge for cause. And that is used when somebody is not able to be impartial. Each side has an unlimited number of excuses for cause. Now, the judge has to agree that it's a legitimate reason to be excused for cause. But if somebody has demonstrated they can't be impartial because of the nature of the charge, because they've heard about the case, because they know the people involved, things like that, then a judge would excuse them. They wouldn't serve on that particular case, and we move on to the next person. Each side, the government and the accused, have an unlimited number of challenges for cause. That is, if everybody in the jury pool, that is, the veneer, has an opinion about the case that suggests that they can't be fair and impartial, then they would all be excused. Now, that doesn't happen too often because normally you'll find a number of people who haven't heard about the case, don't know the parties, don't have a particular interest in the charges that are being brought, who can be fair and impartial. But the point being made is that if there is a challenge for cause and it's based on the individual not being impartial, then they can be excused. And each side has an unlimited number of those. It's important to understand that they're not bound by a certain number of challenges for cause. So what about the process by which somebody is not excused for cause? That is, they say and they represent they can be impartial. Can an attorney or a defendant still excuse somebody because they don't want them as a juror? And the answer to that question is yes, they can. Along with excusing people for cause, that is, having a legitimate reason to excuse them, each side in a criminal case is afforded what are known as peremptory challenges, spelled Peremptory. Peremptory challenges are the ability for a party to excuse somebody from a jury without the party giving a reason for excusing them. In other words, there are free spins, if you will, free excuses. You don't have to state a reason. You simply get to excuse them because you don't want them. However, there is a limit in the number of peremptory challenges that each side can excuse. Every state is a little bit different, but let's just focus in Michigan. In Michigan, if you are charged with a misdemeanor, then you and your side, as well as the government, the other side, have the ability to excuse 3 jurors peremptorily, that is, with a peremptory challenge. So we're going to have 6 in the jury box. We excuse all the jurors for cause that should be excused for cause, and then each side gets 3 excuses that are peremptory excuses, that is, without a reason. If they are charged with a felony, and it's a non-capital case, that is, the person isn't facing the possibility of life in prison, then each side gets 5 peremptory challenges. That is, the government and the defendant can excuse 5 jurors through this peremptory challenge process. If it is a capital offense, that is a crime where the maximum penalty is life in prison, then each side gets 12 peremptory challenges. So it depends on the charge that decides how many peremptory challenges you get. So Let's take a capital case. Let's talk about an armed robbery case. Maybe it got a little bit of publicity. Maybe the store owner who was the victim of the armed robbery is a reputable member from the community, and the press talked about this. It was on social media. So we bring in, when it's time for the trial, a number of jurors from the veneer, and we're trying to form a petit jury, that is to hear the case. We go through challenges for cause. We get rid of the people who have a particular opinion. Maybe that's 10, 15, 20 people from the jury veneer. And now we're focusing on those people who say they can be fair and impartial, who can't be excused for cause. And now the individual sides are eliminating a prospective juror because they just don't want them there. Each side has the right to eliminate a certain number of those people without giving any reason for doing so. That's in order to make the process fair to everybody. Now, some people got a problem with this. Why should you get these peremptory challenges? If the person can be fair and impartial, why does an individual get a right to excuse somebody without giving a reason for doing so? Our system is set up such that so long as both sides have the same number of peremptory challenges, then everybody should be ultimately happy with the group of people. When I was a prosecutor, I think a lot of times people would focus on eliminating people for peremptory challenges when you're starting to think, can they be fair and impartial? Some of the saying goes, you want to eliminate people who tend to be more merciful, that is, members of the clergy or faith. One would think that maybe they would be more likely to convict. Some people have the theory that maybe they're more merciful and they'll find somebody not guilty on a case. If it's a case that involves a lot of highly technical stuff, you want to be certain that you have the right people in the jury box who are listening to the case, who can follow along with that. If they're not able to follow along, that may make a decision as to whether or not you want them in the jury or not, depending on the high level of sophistication regarding the issue of the evidence presented in. There's all kinds of theories about whether or not you want to have a particular person in the jury, and each side is given that opportunity to exclude people without giving a reason for doing so. Some people who have the means hire jury consultants in that regard to help them who should be excluded when there isn't a legitimate reason to exclude them, that is for cause. The question comes down then is, are there any situations in which an individual who's a prospective juror, who's going to be excused possibly peremptorily, that is with peremptory challenges, that shouldn't be excused? This came up in the case of Batson versus Kentucky, which is at page 494. It's more in a footnote at footnote number 171. What happened in the case of Batson versus Kentucky is that the state of Kentucky had prosecuted this individual. He happened to be an African-American male. And during the peremptory challenges, the state was eliminating, that is, using the peremptory challenges to remove jurors that were of the same color, that is, that they were African Americans themselves. At some point in time, Mr. Batson objected and said, you can't simply use your peremptory challenge